Good morning, everyone. Welcome back to day 2 of jury selection. If you'll stand and raise your right hand, we need to swear you in again.
Everyone please stand. Raise your right hand.
All right, for the record, we're handing hearing aid to the juror in seat 41.
Do each of you solemnly swear that you will answer truthfully all questions asked of you as prospective jurors so help you God?
All right, have a seat, folks. Can everyone hear me? Is anyone having trouble hearing me? You are? Can you hear me now? Yeah, okay. I can't yell all day, so I'm just going to take the mask off since folks are having trouble hearing me. All right. Good morning. Welcome back. We're going to be asking you a series of questions today. This is phase 2. This is individual questioning that's done during this phase. But I start you as a group because I have some instructions for you and some additional information about the case to give you before we start asking you questions, all right? So let me start by telling you the charges in this case. Mr. Loyd has been charged by indictment. An indictment, this is a copy of it, it's just a piece of paper that tells people what it is they're charged with. This is how we do it in the state of Florida. You have to tell people, we're accusing you of doing these things, and this is how we do it. Indictments are not evidence of guilt, and they're not allowed to be used by you as evidence of guilt. Does everyone understand that? You can't assume because somebody's been charged with a crime that they committed a crime. So he's been charged with count 1, first-degree murder with a firearm of a law enforcement officer. Count 2, attempted first-degree murder with a firearm of a law enforcement officer. Count 3, aggravated assault with a deadly weapon. Count 4, carjacking with a firearm. And count 5, possession of a firearm by a convicted felon. These cases, they're called capital cases, and the reason they're called capital cases is because the first count, first-degree murder of a law enforcement officer, is a count that is eligible for the death penalty. And that's the only one, all right? The penalty for first-degree murder in the state of Florida is life without parole, except in certain cases where there are aggravators present where the death penalty becomes an option. This is one of those cases. And the reason that we're talking to you about the death penalty is not because we're presupposing anything, but because we need to know that you're able to go through the process with us and do your job as jurors. So the way the case is tried is the first phase is the guilt phase. And the guilt phase in these cases, guilt phase is when you determine whether or not someone is guilty of the charges that have been brought against us. It's conducted the same way as we do all criminal cases. You will be asked to return a verdict of guilty or not guilty on all counts. Your verdict must be unanimous on all counts, meaning that each juror must agree on each count either to acquit or convict. The burden of proof for the state is the same in the guilt phase of a capital case as it is for every other type of criminal case. It is proof beyond a reasonable doubt. And the instruction you will receive on reasonable doubt is identical to the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you're deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not of the charges, including murder 1, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree as well as any other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you as jurors to carefully consider the facts before you reach a decision. The fact that a defendant may face a death penalty is to play no part at that stage of the proceedings. If and only if the jury returns a verdict of murder in the first degree, the jury will then reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. If that happens, there's a special set of rules and instructions that come into play. But right now, I'm just going to give you an overview of it. This second phase is known as the penalty phase. Because the death penalty is reserved in Florida for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which jurors are to consider in reaching a verdict in a death penalty case. The circumstances that the state would rely upon, they're called aggravating factors. Aggravating factors are legal reasons to sentence someone to death. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt. They are limited in number by statute. The defendant relies on things called mitigators or mitigating circumstances. These are reasons to sentence someone to life in prison without the possibility of parole. And I will tell you that that sentence means the defendant will die in prison. There is no parole in the state of Florida. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Mitigating circumstances need only be proven by the greater weight of the evidence. Mitigating circumstances are not limited by statute, and they may include matters relevant to the defendant's background or character or the circumstances surrounding the offense, and they are offered as a basis for a verdict of a sentence of life in prison without parole. Before you may vote, the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. The process of weighing aggravating factors and mitigating circumstances to determine the proper punishment is not a mechanical or mathematical process. In other words, you don't count the number of aggravators versus the number of mitigators. That's not how it's done. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. The decision to vote for either a life sentence or a death sentence is an individual decision. It can be discussed as a group, but it is an individual decision. And the decision on how much weight to give mitigators and aggravators is an individual decision, although you can discuss it as a group. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, that vote must be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Again, this is a very broad and very quick overview of what these cases are like. There are detailed instructions that are provided at each phase of the case. I just wanted you to understand how this works so that the questions that we ask you today are in context for you. Let me emphasize this also. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or the other as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility, and we need to know that you can do your job as a juror if you should reach that phase of the case. We are going to be asking you some questions about the death penalty, some of them so that you can start thinking about this while you're in the jury room. You may not get asked all of them, but you're going to get asked some of them, such as whether you have a religious or moral objection to the death penalty, whether you are someone who believes that the death penalty should be automatically imposed for anyone convicted of first-degree murder, or you can agree with the premise that a sentence of death is not appropriate for all first-degree murder cases. You may be asked whether you would agree to weigh the aggravating factors and mitigating circumstances with an open mind and determine whether death or life in prison without the possibility of parole will be an appropriate sentence. You will be asked whether or not you're so opposed to the death penalty that you simply wouldn't impose it in any case. Many people have strong feelings about the death penalty, both for and against it. The fact that you have such feelings does not disqualify you to serve as a juror, as long as you are able to put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of this state in delivering your verdict. I additionally want to inform you that Mr. Loyd has raised in this case a defense of not guilty by reason of insanity. There is an insanity instruction. I'm just going to read you, again, just a little blurb about it so you have some idea of what it is. A person is considered to be in, oh, and one more thing. The burden in this matter in proving insanity is on the defense by clear and convincing. The person is considered to be insane when he or she had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and the consequences, did not know it was wrong. And lastly, I'm going to read you a statement about the case. Again, this is a condensed statement about some of the facts that you would be hearing in a trial. On the morning of January 9, 2017, the defendant, Markeith Loyd, is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide. When it is alleged that Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That statement I just read you about Ms. Dixon and the unborn child and that conviction, I'm instructing you right now, that cannot be used to determine whether or not Mr. Loyd is guilty of this case. Those facts are being offered for a different reason, that if you are on the jury, you'll get a specific instruction about what you can use that information for. Right, but we're giving you the information because I'm about to ask you all a question, and I need you just to raise your paddles. Don't say anything, don't tell me anything, which is this. How many of you have heard about this case prior to jury service? All right, so I have juror in seat number 40, 41, 49, 57, 59, 60, 3, 4, and 6. All right, of those of you that have heard about the case, how many of you have formed an opinion as to Mr. Loyd's guilt? Raise your paddles, please. I don't see any paddles. All right. All right, folks, I'm going to send you back into the jury room. Juror in seat number 40, you just stay here because we're going to start asking you questions. If the rest of you will return to the jury room, there's coffee back there. Just relax. We'll bring you out as soon as we can. Thank you. And if you could move towards the middle so we can see you, that'd be great. Thanks. All right, so you're juror number 92, correct? You're back.
Yeah.
Okay. All right. Let me start with, you said you've heard something about this case. What have you heard?
Basically the day before, or the morning before I came here, I saw on the news that they were selecting jurors for this case.
Okay, did you hear them describe what the case was about?
No.
All right. Is there anything about what you heard? Have you ever talked to anybody about the case or heard anybody else talking about it?
No.
Is there anything about what you heard that led you to form an opinion as to whether or not Mr. Loyd is guilty?
No.
You understand that in order to serve on a jury, you have to be able to presume he's innocent until and if the state proves he's guilty.
Yes.
Can you do that?
Yes.
All right. Can you tell me what your position is on the death penalty?
For the death penalty.
You're for the death penalty?
Yes.
Okay. So you don't have a religious or moral objection to it?
No.
All right. When you say you're for the death penalty, can you explain to me what you mean by that?
If a person commits murder in the first degree, that's like, if I'm not mistaken, that's intentionally killing someone, then they shouldn't have a right to live.
So you think if someone is convicted of first-degree murder, they should automatically be sentenced to death?
In most cases, I would say yes.
You understand that the law in Florida says you have to fairly weigh and consider a life without the possibility of parole sentence. In fact, the regular sentence for first-degree murder in Florida is life without the possibility of parole. The death penalty only comes into place in certain cases where there are certain aggravators proved. Do you understand that?
Yes.
So if you were a juror sitting in this case and you listened to the penalty phase, as I told you, the state would be presenting their aggravators, their reasons they believe the death penalty should be imposed. The defendant is presenting his mitigators, their reasons they believe life without the possibility of parole should be imposed. Would you be able to fairly and openly consider a life sentence, or would you automatically vote for death?
I could deliver a fair sentencing.
Right. And again, I'm not looking for a particular answer. Nobody is. We just need to know what you truly believe. So you believe you could go through a weighing process, and if the evidence and the facts led you to a life sentence, you would impose life?
Yes.
Okay. Can you, if in the guilt phase of the case, if Mr. Loyd presented evidence that convinced you that he was insane at the time of the offense, would you be able to vote not guilty?
Yes.
Okay. And can you follow my instructions about not using the Dixon case for guilt? You can't assume because of the conviction and life sentence that he's guilty of these cases. Could you follow that instruction?
Yes.
All right. Thank you, sir. I'm going to turn this over to the attorney. State, you may inquire.
Good morning, sir.
Oh.
You just indicated to the judge that you were in favor of the death penalty.
Yes.
Okay, now, do you understand that the law in Florida is that just because someone is convicted of first-degree murder, no matter how egregious that murder is, there's no such thing as an automatic death sentence. The jurors have to think about the evidence and talk about the evidence before they come to that decision.
Yes.
Do you agree with that?
Yes.
Okay, are you able to do that?
Yes.
Judge Marquez also mentioned things called aggravating circumstance, which are those circumstances or factors that make a murder more egregious than other murders. Okay, and only if we are able to prove an aggravating factor beyond a reasonable doubt does the case become eligible for the death sentence.
Right.
Do you understand that?
Yes.
Okay. Now, no matter how many aggravators are proven, and no matter how bad those aggravating factors are in your opinion, would you be able to still listen to mitigating evidence or evidence that suggests a life sentence is the proper sentence in this case before coming to your final decision?
Yes.
Okay. Do you think that Mr. Loyd deserves to have a juror who is open-minded and will listen to all the evidence, especially the evidence of mitigating factors, before the jury comes to a decision?
Yes.
Now, this isn't the time to talk about the details of, or the evidence that is going to be, that'll pertain to each aggravating factor or a mitigating factor. That's at a different time, not now. So, can you assure me that if I stand here and talk about all these different mitigating factors or aggravating factors that you may hear about, would your answer always be, yes, I can listen to it and I can consider those factors before I make a decision?
Yes.
Once you listen to the evidence of the aggravating factors and the mitigating factors, you and your other jurors would have an opportunity to decide whether the evidence proves those factors exist, and if the evidence does prove they exist, you then can decide how much weight or how much importance to give each of those aggravating factors and each of those mitigating factors. Okay? Does that make sense?
Yes.
So after you consider that, you can decide to give an aggravating factor or a mitigating factor. You can say, that's really not important in my decision. I'm not going to give that much weight to that factor. Or you can say, that factor is really important in my mind, and I can give it a lot of weight, or anything in between.
Yes.
Why do you think it is so important to have a juror to be able to listen to the mitigating evidence and truly consider that evidence before coming to a final conclusion? Why is that important to you?
That's justice. I mean, everyone has to have an open mind. This is a case. I got to listen to the evidence.
Do you think it is important in the criminal justice system to have jurors who keep an open mind?
Very.
Can you do that?
Yes.
Judge Marquez mentioned that the issue of insanity is likely going to become an issue in this case. That inherently deals with mental illness. So I don't mean to get too personal, but I do have to ask a couple questions. Has mental illness affected you or a close friend or family member in any way during your life?
Not that I'm aware.
Okay. Do you think that mental illness is a legitimate issue with certain people in society?
Yes.
Okay. Some people think, oh, mental illness, that's just bogus. I don't believe in that. You're not one of those people, are you?
No.
Okay. Would you be able to listen to the evidence about mental illness and wait till you hear all the evidence to determine if a mental illness exists in this case and what effect that has?
Yes.
So again, you can be open-minded.
Yes.
Thank you, sir. No other questions.
Thank you, Mr. President. Mr. Lyman, you may reply.
How you doing, sir?
Fine.
How old are you?
I am 20 years old.
Is this your first experience in the criminal justice system serving as a potential juror?
Yes.
Exciting stuff for you?
I guess.
And what kind of work do you do?
I'm a dishwasher at Mediterranean Blue.
Okay. So here's the thing about our court system. We all know, prosecution and the judge, how important it is to gather accurate information, true information, from jurors, because sometimes a juror may not be the person that should serve on a potential case.
Okay.
You agree with that?
Yes.
That Mr. Loyd is entitled, as is the state, to have someone who is completely honest and straightforward.
Yes.
And sometimes, you know, we have folks come in here and it's not intentional, but they actually kind of, depending on how the questions are phrased, they're called leading questions. Leading questions suggest a fact, and a person can say yes or no. It makes it easier for the party asking the leading question to kind of get the information they want. You understand?
Yes.
But the most important information you gave today was what you said initially when you were talking to the judge about your belief in the death penalty. And I want to talk to you about that, okay?
Okay.
You said if a person commits a murder in the first degree, that's like, if I'm not mistaken, that's intentionally killing someone, and they shouldn't have a right to live. You remember saying that?
Yeah.
Okay, tell me about why you said that.
That's, I don't know why. I don't know how to answer that question.
Do you believe that?
Yeah.
Okay. And the reason I brought up about the leading questions, and everyone wants to say the right thing, okay? But what we need to have is the truth. And it seems to me that, and I'm not going to ask you a leading question, I'm going to ask you an open-ended question, so you can tell me about it. Why do you feel that way? Why do you feel that if someone commits an intentional murder, that they should receive the death penalty?
I don't think the state should be paying for their well-being and treatment while they're in prison,
Okay. So
while they've
go ahead, I'm sorry.
actively killed somebody.
Okay. So I want to talk, we're going to talk and focus on that a little bit, okay? And we'll get back to the other stuff in a second, okay? Where did that belief originate from? Where do you think, when did you start feeling that, and why?
I don't really know when I started believing that. I just kind of feel that way.
Okay. And you're 20 years old. Have you had that belief for some time?
I guess.
Okay. And do you think the death penalty is a cheaper way to eliminate someone who has killed someone than putting them in life in prison?
Well, it's cheaper, I guess.
Okay. And what is the reason that you believe that that person shouldn't get life as opposed to death if they committed an intentional murder?
Because they took another life, another human being's life.
Okay.
They shouldn't be living theirs, like, just by off nothing, off the taxpayer, off the state.
Okay. And do you think that the only just sentence for someone who commits intentional murder is the death penalty?
I did think I said that, but now that I'm considering it, I don't know.
Tell me what your thoughts are about that.
There's just a lot of variables, a lot of circumstances.
Okay. But apparently you have a very strong feeling about the justice system applying a death sentence to an intentional murder as opposed to a life sentence. Is that right?
Correct.
Okay. And is that something you would be thinking about, obviously, if you were part of this jury?
Yeah.
Okay. Judge, can I come sidebar?
Yes.
Thank
All
you,
right,
sir.
All right, sir, we appreciate your willingness to serve in this case and the time that you've spent with us. I don't think this is the case for you, so I'm going to excuse you as a juror in this case. You're free to go, but you can keep that mask.
Oh,
All right,
thank you
thank
so
you.
much. Oh, sorry.
Juror in seat 41, please. Good morning again. Can you hear me? All right. All right. We're just going to be asking you a few questions today. I'm going to ask you some questions, and the attorneys will have a chance to do so. I'm going to ask you to keep the mic up near your mouth so that we can hear you and speak up. And remember, you have to use words.
Okay.
Not. So let me start with, you said you've heard about this case. How'd you hear about it?
Just from what I saw on the news
And what did you see on the news?
about when it happened, when he was at Walmart, when he shot the officer, how he was trying to get away, and pretty much that was it.
Okay. Was it something that was being talked about at your, among your family, your friends, your coworkers?
No, ma'am.
No? So you didn't have any conversations with anyone about it?
No,
Since it happened, have you watched any of the news coverage?
not about that, no.
What about, have you watched news coverage about something else concerning Mr. Loyd?
No, I haven't watched anything else on him about that. Only what's come on the news. If something comes on TV about him, I just turn the TV away.
Okay. And I don't mean since jury service, I mean since it originally happened, throughout the years, have you watched any news coverage on it before you came here?
No, not really.
All right. How about Facebook, the internet, newspapers, anything like that?
I saw a couple on Facebook, like on YouTube, when they was talking about the trial, but not necessarily the whole thing.
Okay, so you watched parts of that?
Right.
All right. So based on that, did you form any opinion as to whether or not Mr. Loyd's guilty?
I mean, I just think it was wrong for what he did, supposedly, but I didn't really have an opinion on it.
Okay, so based on what you saw, do you believe that he did the things they said on TV?
Yes, ma'am.
And you believe those things to be wrong?
That what he did?
Yes, ma'am.
Absolutely.
Okay. The way the jury system works is jurors have to be able to presume that Mr. Loyd is innocent. In other words, presume nothing happened until and if the state can prove he's guilty. You follow that?
Yes, ma'am.
Do you think you could do that in this case, or are you going to have some lingering thoughts about what you saw?
Probably some lingering thoughts about what I saw.
All right. State?
State moves, Your Honor.
Thanks. Any objection? I'm sorry? Sure. Okay.
How are you doing, ma'am?
I'm good. How are you?
Good. Now, you heard the judge read something about that Mr. Loyd has already been convicted and sentenced to life without the possibility of parole
Yes, sir.
on the killing of his ex-girlfriend, Miss Dixon, and the unborn child.
Yes, sir.
Were you familiar with that case also?
Only from what I saw on the news, like I said before. I didn't go into whole detail. I just saw the part where they say he killed her and she was pregnant, and that was pretty much it.
Okay.
When something like that comes on the news, it saddens me, so I don't like to really watch it or go into it.
Okay. Now, have you had an opportunity to spend time, especially since you found out you were going to be on this jury on Friday, between now and then, thinking about your feelings in terms of Mr. Loyd's guilt or innocence?
A little.
And did you ever, in that space of time, go over to the side that said, you know what, I know I feel this way, but I can put it aside?
Honestly, no.
Thank you, ma'am. No objection.
All right. Thank you, ma'am. Based on that, it would be hard for you to do your job as a juror. We appreciate your willingness to serve. I'm going to excuse you as a juror in this case.
Okay.
You're free to go.
Thank
and the
you.
mask is all yours.
Thank you.
Thanks. Juror in seat 49. I'm sorry, 40, yeah, 49. 42 is coming back later. Good morning.
Morning.
You're juror number 448, is that correct?
Yes.
All right. All right, so I'm going to be asking you some questions, and then the attorneys will get a chance to ask you some questions. There's no real rules. We just need to know what you actually think. So just tell us the truth. You're not getting graded. There aren't any right or wrong answers, all right? You said you knew something about this case, or you'd heard something about it. Is that correct?
Yes, yes.
Where did you hear about it?
Just news throughout the years. I follow the WFTV, like Channel 9, and I've seen that before. And a while back, I have my sister's mother-in-law and sister's husband both work in law enforcement here in Orlando. And
What agency do they work with?
Orange County.
The Sheriff's Department?
Yes, I believe so, yes.
Okay. Have they talked to you about the case?
There's a- Yeah.
It's a fickle microphone. It's not you. Yeah.
I think it was. Oh, sorry.
Go ahead.
Yeah, sorry. I know. That's pretty.
All right. What about that conversation stuck with you?
Just that comment and just the matter of the case and stuff. Yeah.
All right. How much, so all told, how much coverage do you think you've watched of all of this?
I mean, not a lot. I don't like watch the news, but I mean, I follow them on like Facebook and Instagram, like the WFTV. I just recognize the face and the incident and who was accused of and stuff.
So based on all that and the conversations that you had and, with law enforcement, all of which are fine, there's nothing wrong with what happened, but with you having those conversations and seeing the news stuff, did you form an opinion as to whether or not Mr. Loyd is guilty?
I mean, it's tough to say. I mean, I mean, maybe at the time, but I mean, it's just kind of hard to say, but
Okay, so
maybe,
at the time,
maybe, yeah. I mean, you hear people talking around you, you just kind of, you just assume, you see it on the news, it's just tough,
so you assume what? I don't want to put words in your mouth.
I understand. I mean, I would just, you just kind of see it, and I mean, I like to have an open mind, obviously, but, in the back of your head, you probably assume that, he's guilty.
Okay.
Yeah, it's just hard, yeah.
It's understandable.
Yeah, I'm sorry.
So you don't need to apologize for that, sir. Being human is fine.
Yeah.
There's no reason to apologize for that. Jurors have to be able to presume Mr. Loyd to be innocent.
I understand.
Until and if the state proves he's guilty. And if you can't do that, that's fine. This isn't the case for you. Can you presume him to be innocent, or do you think in the back of your mind you'd be thinking, I don't know, I think this guy's guilty?
I'd like to think I can have an open mind, but it might be difficult. I just don't know if I'd be the best fit. I'd love to be on a jury, maybe, but just for a different case. I think, to be honest, yeah.
I understand that. Thank you.
Yeah.
State?
Yeah.
Any objection? All right. I hope you get on a jury. It's rare that we have people who are willing to serve, and we appreciate it very much, but this probably isn't the case for you. So I'm going to excuse you from this panel, and have a good day, sir.
Thank you. You too. Thank you.
Thanks. You can keep that mask. Thanks. All right, juror in seat 50. Is the juror in seat 50 here? Yeah. Let's bring her in, please. I'm sorry? Yeah, I thought they were, yeah. I just realized I'm looking at a different list. I have varying lists. Good morning.
Good morning.
How are you doing this morning?
Doing okay.
Okay. I know this is, a little nerve-wracking for folks, so try and relax. You're going to have that mic closer to your mouth so that we can hear you. We're going to be asking you some questions. I'm going to ask the questions first, then the attorneys have a chance to talk to you. You just need to tell us the truth. Don't worry about your answer and whether it's right or wrong. There really aren't any right or wrong answers to these questions. They're just what you actually believe and think, okay? So you did not indicate that you'd heard anything about this case, is that correct?
Correct.
So you've heard nothing prior to coming into this courtroom about the case?
No, I've heard nothing.
Has anybody talked to you about it, anything like that?
No.
No? Okay. Do you have any religious or moral objections to the death penalty?
I haven't personally decided about how I feel about it yet. I would say that I somewhat sway to not having a death penalty, but if I'm provided with correct evidence, I might be swayed the other way.
All right. So this isn't something you've thought about a lot?
I've thought about it, but I haven't put a stance on it yet.
The way this works in the state of Florida is jurors on these types of cases have to be able to fairly consider both sentences. The way it works, as I was explaining to you, if Mr. Loyd was convicted of first-degree murder, then there's a penalty phase. The state's going to present evidence to you of the reasons they believe he should be sentenced to death. Those are called aggravators. The defense is going to present to you the reasons they believe he should be sentenced to life. Those are called mitigators. At the end of that phase, when all the evidence has been presented, I will give you some jury instructions as to how you deal with this. But basically, you go back in the jury room with your fellow jurors. You can talk about it as much as you all like or as little as you want. We don't direct what happens in a jury room. All right. It's your decision individually. Like I said, you can talk about it, but in the end, it's your decision what your vote is on this. But you will be asked to and directed to weigh the aggravating circumstances and the mitigating circumstances, consider all the evidence and the facts. Can you do that?
Yes, ma'am.
Let me ask this in stages, all right. So if, after considering all of that, the evidence and the facts led you to believe that the appropriate sentence in this case was life without the possibility of parole, would you be able to vote for that?
Yes, ma'am.
Right. If the evidence and the facts led you to believe that the appropriate sentence in this case is death, would you be able to vote for death?
Yes.
Okay. You hesitated and looked left and right. So tell me what you were thinking.
I just wanted to make sure that I answered correctly before, I just wanted to think about it before I gave you an off-the-bat answer, just to make sure that if it's something that I'd have to choose, I know that I'd choose it correctly.
Okay. When you said you have to choose, what do you mean by that?
I wouldn't want to go home with any kind of regret or feeling.
Can you speak up just a little bit?
Oh, yes, I'm sorry.
Sorry.
I wouldn't want to go home with any kind of regret or feel like I would make the decision based on my moral objection. So I just want to make sure that I'm able to say yes today so that I won't go back in the next like 3 weeks and then decide to change my mind about it.
Okay. So you have a moral objection to the death penalty. You just said based on my moral objection.
I want to say it's like a 25% moral objection.
A 25%, you said?
Yes, does
Okay.
that make sense?
That's fine. These are not normal questions that you're being asked. They don't come up in your normal life. So it's fine if you need a minute to think about it. So let me ask you a different question, which is, as I told you, Mr. Lloyd's raised the defense of insanity. The burden's on the defense to prove that by clear and convincing evidence, and it would be in the guilt phase. It's not in the penalty phase. If at the end of the guilt phase, you believed that they had proven it, would you be able to render a verdict of not guilty by reason of insanity?
Yes.
And can you follow my instruction about you can't use the conviction and life sentence on the murder of Sade Dixon and her unborn child? You cannot use that to decide whether or not Mr. Lloyd is guilty of these charges.
Yes.
Can you put that out of your mind when it comes to making that decision?
Yes, ma'am.
All right, thank you, ma'am. I'm going to let the lawyers ask you some questions now. I appreciate it.
Okay.
Mr. Buxman, you may inquire.
Good morning, ma'am.
Good morning.
Now, when Judge Marquez asked you basically if you would be able to vote for death, if the evidence supported that, and if you felt that was the right sentence, there was a long pause, and you basically said you wanted to make sure you were answering it correctly. Do you, whether to vote for the death penalty is going to be an individual decision, assuming we get that far in this trial, is an individual decision for you to make. Okay, do you understand that?
Yes.
There is nothing, no matter what the evidence shows, and no matter what the law is that is described to you, there is nothing that would ever require you to vote for the death penalty. Okay, if it's your individual decision. Okay. Do you understand that?
Yes.
When you said that you had a 25% moral objection to the death penalty, I think that's what your words were. Even if I'm wrong, please tell me.
No, you're correct.
Talk to me a little bit about that. What do you mean?
25% because of my religious background, I think does play part in my moral by sometimes I feel like God should be the one to decide when and where you should die. But then another side of me is like, well, we have free will and we have a justice system in order to put people where they should be placed. So I want to say that that rational other side of me takes more over than my religious views.
Okay. Are you a very religious person? I'm not going to ask any other details about that, but are you very religious?
I wouldn't say religious, I'd say spiritual.
Okay, I understand. Do you think if you're selected for this jury and you're back deliberating about what the proper punishment would you be struggling between that spirituality and the evidence in the law in this case, that internal struggle you'd be going through?
No, I think I've done a pretty good job in the past of differentiating between the two, so I'd be able to pick one side or the other.
Okay. Knowing that the law would never require for death, no matter what the evidence shows, would you be able to, after looking at the evidence, if the death penalty was appropriate in your mind, considering your spirituality, would you be able to vote for death? And before you answer that, it's one thing to sitting around with your friends and family, seeing something on the news, saying, oh, I could vote for the death penalty against that person. And that's a very different scenario than you being here in a real life situation, being put in that position.
So I have an objection that's compound, including.
Overruled. Go ahead. You can answer the question.
putting yourself in a real life situation, would you be able to, if you felt evidence, if you felt the proper sentence in this case was death, would you be able to walk into this courtroom, raise your hand and say that person right there deserves to die for his actions? Looking internally.
Honestly, I'd have to say no.
You'd have to say no?
Yes.
Okay. Thank you, ma'am. No further questions, Your Honor.
Mr. Leiderman?
How you doing, ma'am?
I'm good, how are you?
So we learned from the very beginning that you had a moral objection. And we went through this exercise.
Is your mic on, Mr. Leiderman? I'm having trouble hearing you. Sorry.
Okay. We went through this exercise with both the judge and the state, where you were saying you could follow the law, you believe you could, separate them, and then the prosecutor asked you a pretty long question, which included, you never have to vote for death. You never have to, but can you, so forth and so on. So I want to make it very clear what the law is in terms of whether you would be able to sit on this case, okay? You agree that you have some part of a objection to this based on religion. Is that right? You have to answer out loud.
Yes.
Okay. Now, you also mentioned that, we have rules, society has rules, free will, and that people should be held responsible for their actions, right?
Yes.
So that's the struggle that's been taking place with you in front of both the prosecutor and the judge today. Would that be a fair statement?
Yes.
Okay. The ultimate question is whether you could follow the law. That's the ultimate question. Now, the prosecutor was absolutely correct. You are never required to vote for death under any circumstance. But the way the system is set up, the only jurors that can actually participate in this process, whether they have a moral objection or otherwise, they have to be able to consider the possibility of death based on what the law is. You understand?
Yes.
So here's the law. There are aggravating circumstances. The state's going to present you. As a juror, as a whole, that you have to prove those aggravating circumstances on one aggravating circumstance to begin with, collectively as a whole beyond a reasonable doubt. Could you do that?
No.
So you could even show that the aggravating factors were proven beyond, an aggravating factor were proven beyond a reasonable doubt.
I noticed that when we started talking that I had one opinion, and then towards the ending I kind of had a conflicting opinion. And when he told me to put myself in the real life situation, and after what you're saying, if I had to sit here, I think that the pressure would be a little too hard and I wouldn't be able to make the proper decision of putting someone under a death penalty or considering it.
Because of your moral beliefs.
Yes.
Thank you, ma'am.
Anybody need to approach?
No.
All right. Thank you, ma'am. We appreciate your honesty. At least we gave you some food for thought today.
Yes.
This isn't the case for you, so I'm going to excuse you with our thanks. You're
Okay.
free to go.
Thank you, Judge.
All right, thank you. Okay, I have the juror in seat number 52. What happened? There's no colors for Friday. It's just a new panel. Dear God. One moment, please, ma'am. Thank you. All right, my apologies. How are you this morning?
Fine, how are you?
Good, thanks. All right, let me take this off so you can hear me. All right, we're going to be asking you a few questions. I'm going to start, then the lawyers will take over. There aren't any right or wrong answers to these questions. There's just what you actually believe and think. So just tell us, just answer the question. Don't worry about what the answer is, okay?
Okay.
Let me start with asking you, you indicated that you've never heard anything about this case. Is that correct?
Correct.
So do you have any preconceived notions about this case?
No, not at this time.
Have you ever thought about the death penalty?
Yes.
All right. Tell me what your beliefs are about the death penalty.
I'm not totally against it. I think in certain circumstances, as a society, it's okay.
Okay. So when you tell me you're not totally against it, do you believe that there are any cases where the death penalty should automatically be imposed?
I don't know if cases where it's opposed. I'm thinking more,
No, imposed.
oh, imposed.
I'm
okay.
sorry, that someone should be sentenced to death automatically if they're convicted of a certain type of crime.
Not necessarily, no.
Okay. The way the law in the state of Florida works is first-degree murder is the only charge for which you could even be sentenced to death. And in order for the normal sentence for that is life without the possibility of parole. If there are certain aggravators that exist, then the death sentence becomes a possibility, okay? And as I explained to you, after the guilt phase, if Mr. Loyd was convicted of first-degree murder, you would all then be asked to come to the penalty phase. At the penalty phase, the state's going to give you, or is going to present evidence of the aggravators, the reasons they believe death is an appropriate sentence in this case. The defense is going to present their evidence as to mitigators, the reasons they believe that life in prison without parole is the appropriate sentence. As a juror, I'm going to give all of you the written instructions on how to deal with all this evidence, but you go back into the jury room. You're going to discuss this as a group as much or as little as you all want. We don't direct what happens in the jury room. But you're going to be asked to weigh the aggravators and the mitigators. You can talk about it as a group, but in the end, it's an individual decision for you, okay? So you have to weigh those aggravators and mitigators, decide what importance or weight you're giving to each one of them. So if after all of that, the evidence and the facts and everything you'd heard led you to believe that life in prison without the possibility of the parole was the appropriate sentence, could you vote for that?
I could vote for that.
All right. And conversely, if it led you to believe, if all of that led you to believe that a death sentence is the appropriate sentence, could you vote for that?
I could vote for that.
All right. Do you have any reservations or concerns about your ability to do that?
No.
You heard me tell you about the defense of insanity that Mr. Loyd has raised. So this would be in the guilt phase of the case, when you're trying to determine whether he's guilty or not guilty. If after the burden is on the defense, clear and convincing, but if at the end of the guilt phase, you felt that they had proven that Mr. Loyd was not guilty by reason of insanity, could you render a verdict of not guilty?
Could you repeat that? If
Yeah.
he was-
It's convoluted, isn't it?
Yes.
All right. They've raised the defense of not guilty by reason of insanity.
Correct.
Burdens on them by clear and convincing evidence to present the evidence. So they present the evidence during the guilt phase. This is all hypotheticals we're giving you. At the end of the guilt phase, you've heard all the evidence, everything's come in. You're being asked to render a verdict, to decide the case. And you believe that the evidence does support the defense of it not guilty by reason of insanity. Could you return a verdict of not guilty in this case?
That would be difficult for me.
All right, tell me why.
I just personally feel there's very few instances where I truly believe in insanity.
Okay. So do you believe that there are some people who are insane?
There probably are.
Okay. You said probably. Do you have doubts about that?
A few, yeah.
Can you tell me what those doubts are, please?
I guess it would depend on if the person was insane through an entire long period and people knew that, or if it was just a moment of insanity.
The law allows for a moment of insanity, as you're calling it. I mean, like I said, I only read you a little bit of the instruction.
Right.
But you have to be open to, you don't have to, I mean, jurors can believe or disbelieve any witness they believe, but you can't start the trial saying, I don't believe that. You're going to have to convince me. So are you someone who doesn't believe in a moment of insanity as you described it?
Not by my personal definition of insanity, I think.
All right. Can you put aside your personal definition and follow the law on the issue of insanity?
I think I can do that.
You think you could do that? Do you have any doubts about your ability to do that?
No.
No? Okay. And then lastly, you heard my instruction about that Mr. Loyd's conviction for the murder of Ms. Dixon and the unborn child and the life sentence cannot be used by you to determine whether he's guilty or not of these charges.
Correct.
Can you follow that instruction?
I can follow that.
All right. You can put that aside and just use it when I tell you that it would be, that it's allowed.
Yes.
All right. So you're, all right. Thank you, ma'am. I don't have any other questions for you. State, you may inquire.
Good morning, ma'am.
Good morning.
You started out your answers to the judge's questions about your views on the death penalty, and I believe you said, I'm not totally opposed to it. I think those were your words. Tell me what you were thinking when you answered that question. What's going through your mind?
I think in very rare cases, as a society, it would be okay. It's not something, I personally don't want to feel like I have to judge someone in that sort of instance, but I think there's a difference between, I don't believe every murder or whatever type of case it is should result in a death sentence. I think it should be used very rarely.
Okay. When you said in rare circumstances you think it's appropriate, did you have some kind of circumstance in mind when you were thinking?
You know, I think there's truly a difference between someone acting, I think there can be mitigating circumstances for, let's say, murder, but there are true people that maybe that's in their heart and that they can't be rehabilitated, there's nothing else that society can do for them.
Okay. Would rehabilitation be an important component in whether you think the death penalty is appropriate?
Not necessarily.
Okay. Did you have any other thoughts of those rare instances where the death penalty would be proper to impose?
I think it would have to be where someone definitely knew what they were doing, had evil in their heart and intent, and they did exactly what they wanted to do.
Okay. On a scale of 1 to 10, 1 meaning you would never impose the death penalty no matter what, or never vote for the death penalty, and 10 meaning you'd vote for the death penalty on any first-degree murder that you could think of, where would you be in that scale?
That's tough to say. I'd probably say 5 because so much would depend on what I heard.
Okay, it's pretty much right in the middle.
Yeah.
Okay. And you indicated that in your mind, just because someone commits the crime of first-degree murder doesn't necessarily mean that the death penalty should automatically be imposed. Am I correct in that?
Correct.
Would you be able to listen to the aggravating circumstances in this case, as well as the mitigating circumstances in this case, before you make a final decision?
Yes.
this is not the time to talk about the details surrounding or aggravating or mitigating factors here in this case. That's at a later time. But would you be able to give true consideration and truly, look into the evidence that applies to each of those things before you make a decision as far as what the proper punishment should be?
I believe so, yes.
And as far as the mitigating factors, or those factors that may make a life sentence more appropriate, can you consider any and all mitigation that is brought before you make a decision?
Yes.
If you're selected as a juror, once the case is over and you're sent back to deliberate, the decision of what the proper punishment in this case is an individual decision to be made by each individual juror. Okay? If one juror determines that life is the proper punishment in this case, that will be the sentence imposed. You understand that? It would, in order for the death sentence to be a possibility, it would require all 12 jurors to come back unanimously saying the death penalty is the proper punishment in this case. Now, knowing that the death penalty has to be unanimous, if the jury comes back and that's the jury's verdict, everyone would obviously know that you voted for the death penalty. Knowing that, do you feel confident in your ability that if you felt the right decision in this case was the death penalty, that you would be able to come into this courtroom, raise your hand, and say, this man here deserves to die for his actions?
I feel like I could do that.
Okay. Is there anything in your life or background that you think we should know about as far as whether you could be a fair juror in this case? And things that we've heard in the past potentially is, I had a family member who was murdered. In this kind of a case, that's important for us to know. And it should, if it's important enough, it should just jump out in your mind. Anything like that?
I don't think so.
Okay. No further questions. Thank you, ma'am.
Thank you, Mr. Dutcher. Mr. Lenneman, you may inquire.
Good morning, ma'am.
Good morning.
Now, when we come into a courtroom, even when I was a potential juror, we carry with us sometimes baggage from our life. Sometimes those create an opinion. And sometimes we know it, sometimes we don't. So as I was listening to you hesitate for what I considered a long time when you were asked about insanity, I was wondering why she is hesitating and what that is connected to. And could you tell me that?
I think I'm just being thoughtful that it's not an easy, and before today, I hadn't even heard anything about insanity in this case, or potential insanity. So just being thoughtful.
Thoughtful in what way?
Just with my answer.
Okay. Well, your answer was kind of, I'd have a hard time with that. So you thought that was the thoughtfulness of your answer, that you were sharing, that it would be very difficult for you to?
Correct.
Okay. And so, obviously, that is a defense in this case. And it requires a mental defect, mental illness, and it requires another prong involving knowing right from wrong. And there's some other stuff that goes into the actual jury instruction that you heard. But what concerned me is from the outset, you had said it would be very difficult. I'm trying to understand why, besides being thoughtful, what is connected to that in your life that makes you skeptical? Because that's what I basically kind of heard, that you were skeptical of someone using this as a defense. Am I wrong in that?
I think you're not wrong. I think it would be a very rare case where I felt like it was true insanity. And as I said before to the judge, There's a big difference in my mind between someone who's been mentally labeled insane and for whatever behavior for years versus someone doing it momentarily. Saying
Okay.
that they were insane just for a moment.
Okay. And you kind of said, and correct me if I'm wrong, because I'm working off of memory, but in terms of that momentary issue, you kind of said that may be difficult. Is
For
that-
me to believe that someone's insane for a momentary
Yes.
point of time.
Yes.
Correct.
That may be difficult. And that thought, that feeling would obviously come into the courtroom with you
Sure.
if you're a juror. It's not like you can bury it, right? And would you agree with me that that might bleed over to your decision?
It would depend on what I heard in the courtroom.
Okay, so you can't answer firmly that it wouldn't because you need to know what's presented to you first.
Right.
And so once you find out what's presented to you, then you would be able to determine whether that would bleed into your decision-making process, your skepticism or no skepticism, correct?
Correct.
And you don't have any question in your mind that's the way that would play out.
For me, yes.
Okay. Judge, I have a motion.
Can we see the attorneys at the bench? All right.
Sorry, I'm trying to place my microphone.
Okay.
All right, ma'am, I have some more questions for you.
Okay.
Now, you already heard that Mr. Loyd is serving a life sentence without the possibility of parole.
Correct. In here.
You know that, involving the case of Ms. Dixon. Now, in your mind, knowing that Mr. Loyd or anyone is serving a life without the possibility of parole sentence for another murder, is life ever going to be, on the murder that you are sitting on, a sufficient penalty for the murder of a police officer?
Possibly.
Okay. And what circumstances would that be?
Well, I think
Sustained.
Now, you had talked about the evil in the heart and intent of a person, and that's when you feel that that kind of murder would be something justified for a death penalty.
I do.
Can you tell me a little bit about that?
I think there are crimes of passion where maybe something went wrong and those things happen, but I think there are also crimes where the person totally intended to do what they did, and if they murdered someone totally intentionally, with the total intention of creating harm and chaos and havoc, then I think that's a problem.
Okay.
All right,
And what-
Mr. Lim, let me interrupt for a minute. Let me see the attorneys at the bench, please. Thanks.
I have no further questions.
Thank
Thank
you.
you very much, ma'am.
Hold
Am
on.
I finished?
Yeah, everybody wait until the court reporter gets back into place. All right, ma'am, I'm sorry. We appreciate your willingness to serve on this case. I don't think this is the case for you because of the insanity defense issue, so I'm going to excuse you as a juror in this case with our thanks and a gift of that lovely mask, which you can take up. Thank you so much. You're free to go.
Thank you.
All right, we have 3 people left from panel 2, so I'd like to finish them before lunch. And if you could send jurors 3, 4, and 6 from panel 3 to lunch, tell them to come back at 1:30. Let me finish these 3. The other 3, which is the juror in seat 57, is next. Thank you.